Okay, I'm here with Phil Grant, and I'm John Wertz, Vetting Committee Chair, Montgomery County Tea Party. We're here. Phil is running for Judicial Court number 9 in Montgomery County. With me is Pat Tibbs, she's our timer, Brian Crumby, Del Fessington, Ken Vaughn, and Larry Rogers. And with that, we'll turn it over to you and let you do your up to 5 minute open.
Okay. Thank you all for having me. My name's Phil Grant. I'm currently your first assistant district attorney here in Montgomery County, Texas, and I am running for the 9th District Court. The main reason I'm running for the 9th District Court is I think it's important that we have somebody in that court that has the most experience and most qualifications to deal with a full-time criminal docket. The 9th District Court is a full-time felony criminal docket as it's structured right now, and I don't expect that that's going to change anytime in the foreseeable future. And I have 20 years approximately of experience in felony criminal matters. I've tried approximately 100 felony jury trials, first chair, handled countless motions related to those trials over the years. I've tried everything from capital murder cases to minor offenses, and up and down and back and all through that again. I've practiced in 3 different locations in my career. I started my career in 1996 in Harris County. I moved out to Williamson County, which is north of Austin, where I practiced for a while as a felony district court chief. And then when Brett was elected in January 1st of 2009, I moved out here to Montgomery County, where I've laid down roots, got married, and settled in the Montgomery area, just south of the National Forest. I've specialized in a couple different areas during my 20-year career as a prosecutor: felony, criminal, child sexual abuse, as well as public integrity crimes. Since I've been your first assistant district attorney, I have supervised the public integrity unit, the child sexual abuse unit, the white collar crime unit, and some other groups within our office. I think, just to let you know personally about me, I'm a Marine Corps brat. I grew up all over the United States of America, California, Georgia, Virginia, North Carolina. Went to high school out in Virginia and college at the Virginia Military Institute, where I got my degree in 1993 in economics and business. I immediately went to law school at the University of Texas, where I got my degree in 1996 and started at the DA's office shortly thereafter. And I've been a prosecutor ever since. I wanted and decided I wanted to be a prosecutor in 8th grade when I had a home economics teacher that did a mock trial project in her class. I know that sounds weird, but it exposed me early on to the field, and ever since then it's just been an interest of mine. I followed up that interest with an internship with the Dallas District Attorney's Office, interning with their Major Crimes Division, where my job for the summer was cataloging the Bandito motorcycle gang population in the North Dallas area. And you can imagine, as a college student when you're 19 years old, how fascinating that was. And I was hooked. I mean, I just fell in love with criminal law from that moment forward, and it's been great to be involved in it ever since. I think the citizens of Montgomery County are looking for somebody in the 9th that really is going to be fair and impartial. They want somebody that's going to bring a level of professionalism to that court. They expect somebody that is going to be constitutional and follow the law as written, not as they want to interpret it. And I understand all those demands. I think it's been a difficult time for some people in this county recently with the 9th District Court, and I know there's some polarizing views about that, but I think what's clear from everybody is they want somebody on that bench that's going to be fair and impartial to everybody and to both sides, and to follow the Constitution and stay within the bounds of the law, and not substitute your personal judgment for what the courts and the Constitution clearly lay out as the law in the state of Texas. And that's what I plan to do as the judge of the 9th District Court.
Okay. All right, great, thanks. Why the 9th District Court? There's other courts, of course, in the judicial system in Montgomery County.
Sure.
Why that particular court?
Well, the 9th is a full-time felony criminal court, and that's, of course, my greatest area of expertise in my career is with felony criminal conduct. And I think one of the benefits of specialization in this county, and that move to specialization that the Board of Judges did a few years ago, is that the citizens of Montgomery County really get to elect somebody who's an expert in the field of that court that is specialized. And I believe I'm an expert in the field of criminal justice. I've been doing it for 20 years. I'm board certified in criminal law, which is an extra level of expertise that I've obtained since I've been a prosecutor. And since I've tried that many cases, I qualified for that. I took an additional test. It required a lot of study. And I've obtained that board certification. And I continue to be someone who tries to learn about the field. I've taught all across the state for law enforcement, for other prosecutors on ethical issues, on things that are controversial like asset forfeiture and those kind of issues. So I try to stay on the forefront of what's going on in the criminal justice community. And so the Ninth being a full-time felony criminal court, that's where my heart is. That's how I want to serve this community, and that's why I picked that court.
Okay. Thank you.
Where do you perceive the greatest corruption in Montgomery County is?
In the county or in Montgomery County courts?
In the courts.
Well, as I mentioned, I think that unfortunately we've had some judges that just aren't showing up for work and aren't really putting in the effort and the time that our voters expect. I think that is a huge burden on the taxpayer, not only in tax dollars that are being spent on a salary that isn't necessarily being earned, but it's also resulted in things such as our jail being overcrowded, wasted jury weeks, and a lot of excess costs that probably aren't necessary. You know, you can also look at the fact that increases indigent defense costs, because as the case gets reset and delayed, those costs go up. So I think if you really want to address corruption, and that's a strong word, but you know, you have to hold your judges accountable and ask them to work a full work week and extra, because judges are required to do things 24 hours a day, 7 days a week when necessary.
Okay, while we're on it, just a little follow-on, maybe
Sure.
a little bit follow-on, more of mine than hers, or it could be the same, because you know who that was. But what came first, you entering the race or Judge Case not running for re-election?
I entered the race before Judge Case decided not to run again. By several reasons.
Well, okay. All right, Brian. So just a note, we started 8:10, and we'll finish up roughly about 9:05.
Okay. Yes,
So when it comes to government efficiencies, what would be your list of government functions that is more efficient than the private sector?
Government functions that are more efficient than the private sector. I'm an economics and business major, and I don't really think the government does very well in much of anything. I think that obviously things like national defense, the government needs to be primarily responsible for.
So is that an efficiency thing, or is that for some other reason?
Well, I think they're the organization that is most capable of doing that efficiently. I don't know that they always do perform that function efficiently. But I'm not a huge fan of the government getting involved in much of anything. I don't think that they've proven themselves to be efficient stewards of our tax dollars in any field. Certainly not in healthcare. I think that business regulation is out of control in the United States of America. I'm an economics major. I believe in the free market economics.
So it's easy to say what they're not good at. I mean, that's
What
kind of
they're not
easy.
good at.
But so I'm hearing you say military,
Right?
police,
Yes.
licensing,
What type of licensing?
doctors, lawyers, barbers, anything.
I think to a certain degree, yes.
What else would you add to that list?
Are we talking federal government, state government, local government? I think local government is efficient at education. I don't think state or federal government is efficient at education.
So you
So,
think
I think
government school is more efficient than private school?
local controlled school is better than state and federal controlled education.
Well, no, the question isn't what level of government is the best. The question is what government versus the private sector.
Not much.
Okay.
Nullification.
Okay?
Can
Jury
go many different
nullification?
directions. Can go many different directions. I'd like to get your perspective on where it's applicable, where it's not applicable, good thing, bad thing, pros, cons. Just give us your perspective on nullification.
Jury nullification is a bad thing. I believe that as conservatives, we believe in following the rule of law. If we don't agree with the law, if we think that the law needs to be changed, then we need to go to the legislature and we need to pursue that change in the legislature. I think we see in all areas of government where different officials and folks have just nullified laws because they don't agree with them. And I think that that's dangerous. So I'm not a big fan of nullification when it comes to juries or in other areas of government.
So is it practical for any law to be written that can govern the citizens of Texas? Can you write a law that fits everybody? Is that possible?
Is it possible? Yes, and I think we've done that. The criminal justice system is pretty good at allowing ranges of punishment and allowing for varied circumstances so that you can apply one law to a lot of different fact scenarios.
So how do you apply the law for medical marijuana to be just for the person that would abuse marijuana and just for the person that needs marijuana? Can that be written?
I don't agree that we need a law that allows marijuana for medical purposes at this point in time.
Okay.
All right, under what conditions should a CPS, Child Protective Services, be allowed to make decisions for a child when they have doctors saying they should have one sort of treatment, when the parents have doctors saying there should be another set of treatments?
I think that would have to be in the most absolute extreme circumstances where the safety and welfare of the child is absolutely at risk. I don't think CPS ought to be getting involved in parental decisions unless it's absolutely necessary to protect the safety and welfare of a child.
So, just kind of ballpark nationwide, I mean, should this be something that occurs? We've seen this, I mean, I know there are cases here locally, I know there's national cases. I mean, how rare should that be in a country of 320 million?
I think it should be very rare. I think parents need to be given the right to parent their children. I don't think that the government needs to get involved in that unless it's an abusive situation.
Okay. No guidance as to what constitutes an abusive situation?
Well, I think you know the difficulty in these type of questions, because even though the Ninth is a general jurisdiction, is a specific jurisdiction court right now as by case assignment, I could still be called upon to rule on a CPS case or a family case under certain circumstances.
Right.
So committing to a specific fact scenario where I think that CPS ought to get involved in a case is really not something I should do. I need to leave myself open, but I do think that those opportunities for CPS need to be limited.
Okay.
Question number 4, please describe what you believe the most significant issues in race are and why. And the first one, I'd like you to just expound upon a little bit. You said, will the judge who takes the bench of Ninth District Court follow the law? And you said case was successfully man-abused 5 times, and there may be more before his term is through. I want to restore trust and respect. Explain that just a little bit.
Well, what a mandamus is an action that lawyers can take based on a pretrial ruling. So you're handling a hearing before you go to trial on a matter, and the judge makes a ruling that you believe is legally incorrect. You mandamus them to the appellate courts to get an advisory ruling, well, not an advisory ruling, actually a ruling on whether or not that was incorrect or not. And we've done that numerous times with Judge Case, and we've never not been successful when we've done that. That is an extraordinary amount of mandamuses for any judge. It would be a lot for any judge who had a lengthy career in criminal jurisprudence in the state of Texas. And it's happened in 3 years, and that's not right. You know, that shows one of two things in my opinion. It shows an unwillingness to follow the law or not a very good knowledge of the law, and either one of those is very troubling.
Along that line, you've been a prosecutor for 20 years. Seems like it's gonna be pretty hard for you to not be a prosecutor, thinking cap on when you're a judge.
Well, it's certainly an adjustment. I mean, it would be silly for me to say that it's not going to be, but you know, one of the things that prosecutors swear to do when we take our oath is to seek justice in every case. And I like to give an example of when I was a misdemeanor court chief in Houston, where a kid with severe mental illness was arrested for criminal trespass, and his parents came to court that day and they talked to me about his condition, and they showed me paperwork where he was going to be admitted into a hospital and where he was going to be treated well, and I dismissed that case. And so that was the right thing to do in that case. Being a prosecutor doesn't mean you're always going for the max or always going for the jugular. It's about doing the right thing, and I think that's an easy transition as a judge, to start doing the right thing as a judge, and that's what I plan to do.
You have referenced several times the rule of law in our
Yes.
discussions here, and also in number 4. Adherence and faithfulness to the rule of law requires principled commitment from the person who takes this bench. How does the rule of law differ from the spirit of the law, from your perspective?
Well, I think the spirit of the law is where you get into those discretionary items. The biggest one in the criminal justice system is sentencing. You know, take for example a first-degree felony. In the state of Texas, you've got a punishment range for a first-degree felony that might be probation on the low end, all the way up to life in prison. So as long as you sentence them within that punishment range, you follow the rule of law. Now, what the spirit of the law is what's the appropriate punishment given the circumstances in that particular case. And maybe it was a case where the fact scenarios are such that you really think the probation is appropriate. And some of the examples, and this is not a concrete commitment in any way, shape, or form, but some of the examples that have been discussed that might be on the low end of a case, that might be a murder case, might be a euthanasia circumstance where a husband makes that terrible decision that his wife wants. Now, I don't agree with that decision. That's not the law in the state of Texas. But, that may be on the low end of the spectrum, where on the other end is a violent murder, where it's brutal, it's against a child or something like that. So, the rule of law is, do you stick with within the bounds of what the law says your bounds are? The spirit of the law is how you interpret the facts of that particular case to determine where in the middle that you end up in a particular case. So that's how I think it is reflected.
Okay.
Among the 9 justices of the Supreme Court, which one do you respect the most and why? And which one do you respect the least and why?
I purposely didn't say who I respected the least on the Supreme Court in the questionnaire, but you're going to pin me down. I respect Scalia the most, and that's obvious in my opinion. He's the one who is the strictest constructionist when it comes to interpreting the Constitution. Who do I respect the least? Well, I think we have a couple judges on there that I believe have very openly indicated that they are activists. Ginsburg is one of them. I'm that's not what that position was intended for. in the United States of America. It's not a judicial activist position, so it's supposed to interpret the Constitution, and those that do it, I respect, and those that don't, I don't.
So when it comes to plea bargaining and sentencing and all that stuff, how easy is it for the power of the state to pressure, manipulate defendants into doing something that's not really a fair shake? Does that make sense?
Yes, it makes sense. How easy is that to happen? I think if you had,
And how common?
how common is it?
How easy and how common?
I've been in this business for a long time, and I don't think it's common. I've worked with a lot of prosecutors in several different offices, and I think in general, they always try to do the right thing. Do they make mistakes? Of course they do. They're human beings just like everybody else. Do police make mistakes sometimes? Yes, of course, they're human beings just like everybody else. But I think in general, they try to do the right thing. Now, how easy is it for that power to be abused? Prosecutors have an incredible amount of power. We have over a person's life. Sometimes we have an incredible amount of power. And so, would it be possible for us to abuse it? Sure. And that's why, as somebody who's in charge of hiring at our office, I spent a lot of time trying to figure out how to figure out a candidate's propensity for that kind of thing. And obviously you want people that have level heads on their shoulders, who are gonna look at the circumstances and not abuse the discretion that we give them. Because there's a lot to lose. If somebody's charged with a first-degree felony, they could go to prison for the rest of their life. And sometimes, if you've got a case, you could pressure them to take a plea on a case that maybe the facts weren't there. So you have to hire people that have the strength of character to stand up and say, I don't really think this guy did it. I need to let it go.
How did you determine that when hiring? I mean, what did you use to figure that out?
Well, we ask them a lot of questions about ethics. We ask them a lot of questions about what are you going to do if you disagree with a supervisor's instruction to try a case where you really feel like the person's not guilty. And you try to hire people that have a strong sense of justice and right and wrong. And so far, I think we've been really good at doing that.
Okay, one of the things that's been in the news a number of times in recent months is case backlog related to jail overcrowding, things of this nature. Of course, there's the issue of plea bargaining and how effective that is, when it's appropriate, when it's not. Of course, that affects backlog and
Sure.
jail population, all that. Would you give some of your perspective on all that and what you think the correct approach is for managing caseload and reducing backlog?
Sure. You've got very good examples, in my opinion, of judges that manage their caseload very well. And that's, Judge Mychalk is one of the great examples for how you manage a docket. She puts the appropriate amount of pressure that justice allows on the state and on the defense to get all the work done that needs to be done before a case is set for trial. And then she holds their feet to the fire on those trial dates and gets those cases tried that need to be tried. She's had the highest number of jury trials in the courthouse over the last couple of years, and she is consistently disposed of the most cases, and she also has the lowest amount of defendants that are currently in jail awaiting trial. It can be done, and it's really just about being firm, but being fair, but being firm with both the state and the defense, and saying you need to get your discovery done, you need to get ready for trial, and when you give them trial dates, you need to stick to them, and you need to hold their feet to the fire. And you need to try a lot of cases. Up until the point we're specialized, sometimes we'd only get one trial a month in some of these courts, and that's not enough. You're dealing with about 1,250 defendants coming through any one court every year for those 4 courts that are specialized. If you only get 12 trials a year, that's that's a lot of plea bargaining that has to be done. Now, if you actually have jury trial dockets, say 40 weeks a year, you get a higher percentage of cases before the court on a more regular basis, and more of those cases are going to work out. You know, prosecutors and defense attorneys are very similar in that because of their caseloads, they really don't know their cases that well until they really get them ready for trial. And when they do, a lot of times they realize they can work that case out somewhere that's reasonable for both parties. So getting them before the court for jury trial dockets as much as possible is the way you work out cases. And if you look at Judge Mychok, she's been very successful with
What's
that.
a reasonable number of cases you'd mentioned in here that, in number 9 right now, 9th District, I think you meant to say only 25, you said over 25. Tried in a year in the courtroom, you said we could do better. What's a good number, roughly?
Well, I think you need to shoot for setting at least 45 jury trial weeks a year. Now, are you always going to get a case to trial? No, they're probably going to work out, a lot of them. But you need to have about 45 jury trial weeks a year. There's going to be judicial schools and other things like that that are going to take you away from your courtroom every once in a while. But just because you only have 45 weeks doesn't mean you can't try more than one. You know, one of the problems that we're having in courts is a lot of use of visiting judges. Well, don't use those visiting judges so you can go on another vacation. Use those visiting judges and get 2 cases tried a week. There's nothing wrong with that. So you can double up in a single week on a trial. I was a prosecutor in Harris County. One time I, as a first-year felony prosecutor, tried 3 jury trials in a 2-week period. Can you keep up that pace as a prosecutor for very long? No, it wears you out. But it can be done when you need to get it done. And, you know, one of the benefits that I bring to the table is I've seen big jurisdictions deal with humongous numbers like Harris County does. And I've seen smaller jurisdictions like Williamson County, and then ours is a moderate, in the middle size jurisdiction. We can try a couple cases a week. It can be done, and it's done all over the state. So I think Judge Mychok works hard, and she pushes her cases appropriately, and she gets about 20 to 25 cases a year tried. I think there'll be some friendly competition between her and I across that hallway. And, you know, I think if you're getting 25 to 35 cases tried a year, you're doing a really good job.
Okay.
All right, you mentioned that it's important that prosecutors have discretion,
Yes.
but you also said that you were against juries with nullification.
I'm against nullification, yes, sir.
So why aren't they treated the same? Shouldn't the juries be able to voice their discretion?
Jurors are instructed what the law is, and the law needs to be applied.
And aren't lawyers instructed what the law is?
We are. We are. But I think it's a different circumstance. I mean, when a jurors take the oath, they take the oath to follow the law. And that's the oath as it stands right now. And I think that's the appropriate oath for jurors. Discretion comes into play more when you're dealing with plea bargain and those informal decisions that are made in courtrooms every day. But when those hands are raised and those oaths are taken, the officers agree to follow the law and testify truthfully, and the jurors say they're going to follow the law, and the judges raise their hand when they take that oath to go into office and they say they're going to follow the law. And that doesn't mean they get to nullify. You know, I appreciate that.
Does it mean they can't nullify?
I think that's the way it stands.
Well, not guilty is not guilty.
Not guilty means that we haven't proven our case beyond a reasonable doubt. And if they find that, that's okay with me every day. If I haven't proven my case to you beyond a reasonable doubt, or juries come back with not guilty verdicts, I don't have any heartburn about that at all. The question is about nullification, which means I have proven my case to you beyond a reasonable doubt, and you vote not guilty anyway. And that means you're not following your oath as a juror. That's a difference.
How can you tell the difference?
Well, I'm not sure we could always tell the difference.
Does that same logic apply to nullification of federal laws? Of elected officials?
Give an example. I'm a little unclear what you're talking about.
Well, an elected official not enforcing, say, immigration law.
Okay.
I have the same problem with that too. If a public official has a problem with the law, they should go change it. We have these processes that we've put in place on how to develop legislation and draft laws. Go use them.
So wasn't our country founded, oh, I'm sorry, go ahead, it's your question.
So what about nullification of a federal law that's unconstitutional, such as, some marijuana laws, that they have no constitutional basis to form that law?
Well, then there's processes to find laws unconstitutional as well, and we need to follow those processes.
And the processes are quite lengthy.
Sometimes, but nobody ever said this was easy. That democracy and liberty and all those things, those are big terms, and they're not easy, and it's never easy. But our founders set up a process, and we need to follow those processes.
And are the states part of that process?
Absolutely.
So a governor should be able to nullify.
That's not what the law says. I think if the state feels like a law is unconstitutional, they need to file it with the federal courts, and they need to attack it.
So you believe a federal judge
I didn't say it
has the
always works
interests-
100% right.
has the interests of the state in play?
I think that if that federal judge has raised his hand and they're true to their oath to follow the Constitution of the United States, they'll make the right decision in that case.
So why did a ton of the founding fathers who formed the country, who many of them signed the Declaration of Independence, which basically said when your government imposes injustice on you over and over and over and over again, you have a duty and a right to fight against that and to overthrow it. I would say that's nullification at its finest.
That's revolution, and when we get to that point, I'm not going to speculate on what that point is.
So
In the meantime, I think we need to follow the laws and we need to follow the processes that are on the books.
And obviously, you're not going to comment on this, but what you just told me is that Governor Abbott has absolutely no basis for refusing Syrian refugees.
That's a complicated issue that I haven't dug into. I think there's lots of things that the governor could do to have that practical effect in the state of Texas, and I personally hope he follows every law in the state of Texas that he can follow to get to that result. I think that's going to be difficult for him though in the long run. Yes, sir.
Okay. All right. Number 9, top 3 areas where budget for this office needs to be adjusted. He's stated here that no one is checking to determine if this is accurate, talking about the indigent attorneys being appointed. So there's who determines whether a defendant is indigent or not?
Currently, the process is the defendant fills out some forms, and if the forms are filled out in a way that meet the indigency standards, they're appointed an attorney. It's not checked by anybody.
So it doesn't go to a committee or a group or anything?
No, sir. It's a staff that processes the applications, but there's nobody checking it, which is my big concern. Waco had a similar process, and they found when they assigned an investigator to check into those applications, about 40% of them did not qualify for a court-appointed attorney.
Okay, number 10, what is the single most important action the county needs to do in this great community that we live in? And you said here that judges and public servants need to be held accountable. As district attorney, how do you feel that you've held our elected officials accountable?
Well, when we are provided with a legitimate complaint, a verified complaint, we have always pursued it to the fullest extent of the law.
I've got some more time, plenty of time.
Nope.
I've got 10 hours.
Yeah,
All right, I'm ready to roll.
good
Are
question.
there any guidelines or any specifics that as a candidate running for a judge has to follow? I mean,
Once you declare that you're a candidate, and once you file on the ballot, you have to follow the judicial code of conduct, just like judges do at that point.
give me a couple of
Um,
instances that I can interpret.
Well, I mean, it's about conduct. It's about not endorsing. I mean, judicial candidates can't endorse other candidates. We can only give a certain amount of money to other candidates, and it's really limited. I think it's $100, something like that. So things like that.
Would that apply, because I was at an Eagle Forum deal, and I don't remember what the time frame is that you were talking about that you filed, and when Judge Case said he wasn't gonna run again. But I remember at Eagle Forum, you and Jay Wright were talking about a specific case. Were you outside of that window frame of time that Larry just brought up, from that standpoint, that you guys were discussing?
We were discussing cases finding of the entirety of the online solicitation of a minor statute unconstitutional.
Thank you, yeah.
I believe that I was well within, I don't believe those rules applied to me at the time. However, I think I was well within those ethical guidelines and the comments that I made that day.
Okay. On question 24, to what extent would you need to recuse yourself from cases because of conflicts of interest? I guess needless to say, if you were to win, you were involved in almost all those cases, right? Being the assistant district attorney, is that correct? First assistant DA. And so how long, obviously, you'd either be involved with or have knowledge of the cases that are in process within the court systems, and obviously the ninth, district court. Won't you have to recuse yourself practically from all of those cases and possibly up to a year? And if so, what are you gonna do for income from that standpoint?
Well, no, I think the answer is no, I won't have to, because recusals need to be requested. And one of the things that I did immediately upon making the decision to run for the ninth was we called our staff together and said, hey, listen, I'm running for the ninth. We have other people that can answer questions regarding cases in the ninth. Go to other people and talk to them. Now, are there bigger cases in the ninth that I won't be able to handle personally? Obviously, the Swearingen case for one. Been involved in that litigation for years now. So it's absolutely necessary for me to recuse myself from that particular case. But on cases that I haven't been involved in, haven't had any direct contact, we'll have to deal with that on a case-by-case basis. But as we've talked about, 99% of cases plea bargain. And if I'm not going to interfere with the plea bargain results, then there's really no reason for me to be recused on 99% of those cases. So you're really only talking about the trial cases. And I've already had discussions with the other district court judges about those cases that I need to be recused on, transferring to them, and they'll transfer in new cases that came in shortly after I take office, and we'll balance it out that way. We've always worked it out before. It doesn't result in a judge sitting there twiddling their thumbs. We work it out, and judges have always been good about working those kind of issues out.
Okay. Time-wise, let's see, we've got,
It's been 35, 37 minutes, 38 minutes.
yeah, okay, so we probably have enough time to go around the table one more time.
Okay. Who is endorsing you and what is their relationship?
I have a lot of people endorsing me, and I encourage you to check out my website. I'll keep it up to date as those endorsements come in. Tommy Gage has endorsed me, Brett Liggins endorsed me, some of the constables have endorsed me. COPS has endorsed me, which is a law enforcement group. Some lawyers that are just in general business. And there's some others on that list. And they're all people that have dealt with me over the last 7 or so years who know that I'm a professional, that I do a good job, and that I work hard, and they're people that support me. That's why they've endorsed me.
So on the Rudd case,
Yes, sir.
did you testify in that case? And if you did, what was the summary of that? And then, if you did testify, did you have any involvement in that?
I did testify in that case, and the basic, I mean, I was very limited in what my testimony was. I testified about the process by which we got that case to the Secretary of State and to the Attorney General's office. I also discussed a few of the conversations that I had with some of the participants on the lead up to that investigation.
Participants meaning defendants, or?
Some of the defendants had contacted me during their, deliberations on whether they were gonna do that or not. I did send out a letter from our office advising them as well, not advising them, but notifying them of some of the pertinent laws that were out there. We sent that to all the registered voters in the district, that area. And just, that was the basis of my testimony. It didn't take long in any of the times that I was called to testify, maybe about 10 or 15 minutes.
Okay. Pardon?
He set a record.
I know, that's
question
the
he's ever
shortest
had.
question.
Back on the topic of jail, crowding, and things of this nature, it's been in the news lately that some sentences maybe are too harsh. There's other judges that have been applauded for what we'll call creative sentencing and so forth. In your prosecutorial experience, what experience have you had with what I'll call creative sentencing, or things of that nature that will help with the docket and jail over population?
Well, creative sentencing can mean a couple different things. If you're talking like Ted Poe used to do down in Harris County, where he had people stand on the corners with signs that say "I'm a thief" and that kind of thing, I'm not a huge fan of that. If you're talking about rehabilitative programs like drug and DWI courts and the Veterans Court programs, huge fan of those programs because they're effective, and the studies show that they're very effective. And I think one of the things we need to do in a state is we need to be smarter about how we sentence people. Incarcerating people for extended periods of time, for long periods of time, for low-level drug offenses is just not shown to be cost-effective or have much effect on recidivism rates. We're getting them involved in treatment programs that support them and help them get gainfully employed or learn a skill or those kind of things. Not only are less expensive, but they also show that they're more effective. So the key to those programs is, do you put the right people in those programs? You don't want to put a drug dealer into drug court where he's surrounded by people that have addiction issues. You want to focus on people that have addiction issues that can legitimately benefit from the program.
So why don't you like the creative ones, the Judge Poe one?
I don't think shaming is very effective when it comes to recidivism rates. It's just not, and it's not in the Code of Criminal Procedure as an authorized punishment. So I'm just never been a big fan of those type of processes.
So you wouldn't have sentenced people to the stocks back in the 60s?
If the stocks were in the punishment range in the code, well, then you can consider them. But if they're not in the punishment range that's set up by the Texas legislature, you can't consider it.
Would you have considered
Would I consider putting stocks back into
it?
the?
If it was within the range? That kind of gets back to the.
I think that gets to cruel and unusual punishment, and I'm not sure. And it doesn't serve. Put them in a program where they work or they do something productive, and maybe I can get behind it. But just sitting there, that doesn't do anybody any good.
Right.
Stocks. Did you really just ask me if I would
I did.
put the stocks?
He wants to know if he's at risk
You
or not.
never know what it is.
Got a lot of wood out back.
Wow. I can't wait to tell people about that tomorrow.
Tough.
And this makes the news.
CTP advocates bringing the stocks back.
Seems like a good headline.
What a way to get it
Tough
over
crowd,
with.
right?
Yeah, that is, you are a tough crowd. Yeah.
Is there any such thing as a lawyer on either side abusing the jury selection process? And if so, what can the judge do about it?
Well, there are abuses of the jury selection process, and the main one is the Batson process, and it's when you use race or sex or national origin as a basis for striking a juror when they haven't said anything that would otherwise qualify them for a strike or be a legitimate reason to strike somebody. And there's a motion that's made, and it's a Batson motion, and there's a hearing that's had, and if the judge determines that the prosecutor or the defense engaged in Batson-related conduct, they can reinstate that juror back onto the jury. So, yes, there are ways for judges to address jury selection.
Don't they get like 5 strikes and that's all you decide gets, or?
Well, it depends on misdemeanors or felonies. In felonies, we get 10, actually, for any reason, as long as it's a permitted reason, and it's not race or something like that.
If you're not elected, what will you do?
I'm the first assistant district attorney here in Montgomery County, and it's a great job. I certainly will enjoy being the first assistant district attorney if I'm not elected down the road.
Along that line, if you are elected judge, will that be a step up financially?
It's not much of a step up, and actually, if you figure in the retirement penalties I'm going to be taking, it's really not the
Really?
best financial decision in the world. I'm on the county retirement system. I would have to move to the state retirement system. I'd actually be eligible for retirement in about 5 years if I stayed in county employment. So it's not the smartest decision financially, but that's not why I made the decision. I made the decision because I think this county needs a good judge on that bench, and I think I'm that guy. So it's a little bit of a step up in pay, but the retirement benefits make it a little bit less
Interesting.
attractive.
All right.
May have time for one more question.
Sure.
Back to the stocks. No, I'm just kidding.
Got any recommendations?
Belt lined or wood?
I got iron too. Iron, wood, no problem.
Would it be in an air conditioned situation or not?
Under condition out in the sun. Cruel and unusual. Okay, so back to Brian's question on the Red 7 case. So recently we've had some more of that in the news regarding the MUDs, particularly CMMD1, MUD 148, 24, where there's only a couple of voters in this gerrymandered district. What's the difference between the two? Why do we have some people that are going to trial over this on the one hand, and on the other hand, other than there being newsworthy items, there doesn't seem to be any push to address that?
Well, I think it's difficult for me to comment specifically on it without talking specifically about the RUD. I think it boils down to residency and the fact that these folks are actually living where they're saying they're living in the MUD. They actually live in a trailer, they live there, they get their mail there, they eat their meals there, they commute to and from their work from that actual residence. And I think the main allegations in the RUD case were that those individuals that were charged with those criminal offenses didn't actually reside where they said they resided. Is it a great political, is it a lawful, are the MUDs lawful ways to, make those decisions on bonds and utility costs? Again, that's a legislative issue, and if we don't agree with the way that those things were structured and the legislation that enables mud districts, then we need to address that at the legislative level, in my opinion.
So are you saying the law explains what residency means in the election code?
I believe residency is very well defined in the various codes. Yes, sir. And I know not everybody agrees with me on that.
Probably nobody at this table. Okay, so that'll wrap up all the Q&A around the table. You're welcome to have up to 5 minutes in closing.
Okay. Like you kind of brought up is, what are your motivations for running for this office? And my motivation for running for this particular bench is, we need a good, solid, experienced criminal judge who cares about efficiency, who cares about transparency, who cares about following the Constitution, and cares about efficiency on this bench. I don't think that justice and efficiency are mutually exclusive terms. You can be both, and I think Judge Mychok's proven that. We have an example of a judge who is doing a good job. Everybody seems to say so and think so, and she's very well respected by her peers. She's making good decisions. She's had very little issues in the appellate courts for the decisions that she's made, and she's made a lot of them because she's trying a lot of cases and she's doing a lot of things in her courtroom on a day-to-day basis. She's also one of the most accessible judges that we see after hours and during hours for search warrants and those kind of things, and she makes herself available, and she takes her responsibility to these citizens very it's very sacred to her, and you hear that when you talk to her about how she feels about this position. I've been raised in a home where public service was absolutely critical. It's just what we learned was important to do. That you had to figure out some way to serve your community and serve your country, and this is how I've done it as a prosecutor for the last 20 years. It's time for me to do it in a different way, and that's why I've chosen to run for the 9th. It's all about still serving my community and making this community a better place and a safer place for my kids and your kids and your grandkids, and doing it in a way that doesn't cost the taxpayer a ton of money. I'm a fiscal conservative. I believe that our government needs to be efficient with our tax dollars. I'd like to come in and as a judge, and I would like to, number one, roll up my sleeves and get to work. That's the number one thing I'm going to be able to do to benefit you as a citizen and as a taxpayer. The second thing is I want to look at things like who's getting appointed attorneys in our county. Why is our appointment rate here in Montgomery County so much higher than the rest of the state of Texas, or so on the high range for the state of Texas? Why is that? I don't think our demographics or our economics here support that. I think that we can fix that. And I think people that can afford to pay their way through the criminal justice system need to pay their way through the criminal justice system. And you and me, the taxpayer, don't need to be footing that bill. And there's recent case law that once a person is declared indigent, unless there's a subsequent court hearing that says they're not indigent anymore, we can't even collect those fees or those attorney fees after they're convicted. So, you've got to make that indigency determination on the front end, and we need somebody doing that more efficiently and effectively. I believe in doing the right thing. I was raised that way, and I know that sounds trite a little bit, but that's why I'm running for this bench, is because I want somebody on the 9th District Court from a citizen of Montgomery County perspective that does the right thing every day. And sometimes that's going to mean holding the state of Texas to their burden, expecting them to be prepared for trial and show up and do a good job and try a case. Sometimes that's going to mean holding the defense to that same burden too, of showing up and doing their job as well. And I plan on doing that. And I plan on doing it in a way that's professional and respectful of the people that are there in the courtroom. Everybody who comes into the criminal courthouse who's not a lawyer isn't used to it. It's a difficult process. Whether you're a victim, whether you're a witness, or whether you're a defendant. And I want my courtroom to be a place where everybody that comes in there, even if they are the worst of the worst, leaves saying, well, that judge treated me with respect. He might have given me a life sentence, but he treated me with respect. So I think it's important to do the right thing for the right reasons. I think it's important to have the kind of quality and quantity of experience for this bench that I have. You're never going to be embarrassed by me. I'm never going to let you guys down with the decisions that I make. And I'll do a good job. I really appreciate y'all's support. It would mean a lot to me personally and professionally. And I'd be happy to come back and answer any more questions if you guys want another round. We can talk about stocks for another 30 minutes or so if you want to.
I'd love to.
I do appreciate your time and your willingness to do this process.
Thank you.
Thank you.
Thanks very much, appreciate it.
You're welcome.